as we go through this course is the difference between what everybody knows and what you can prove. It's not enough to just say, look, this guy's a drug dealer, he was dealing drugs. Everyone knows it, his neighbors know it, his girlfriend knows it, he knows it. We will only put someone in prison and take away their freedom if you can prove beyond a reasonable doubt to a jury of 12 that they actually committed the crime you're charging them with. And that's the difference that makes this class important between making that arrest, you know that they did it, and making that conviction, proving they did it. We're going to be looking at things from both the police officer's perspective and the prosecutor's perspective because they have different goals and they need to understand where each other are coming from. If you're going to be working in this system, you have to understand the pieces of the system and the places and positions that other people are going to play. You're not all working for the same purpose, but you're not working at cross purposes either. The arresting officer needs to ensure that the evidence they collect is collected in accordance with the Constitution and the rules of evidence so that the prosecutor can later use that evidence. The prosecutor, meanwhile, needs to assure the officers that he's going to take their cases seriously and that they're not wasting their time. As we go from arrest to trial, you already saw how the officer handed his case over to the prosecutor. The prosecutor might not prosecute a case if she thinks that the evidence is weak or not admissible at trial. Or she may offer the defendant a deal if she's unsure about securing a conviction. We've talked about that last time, and if you have questions, post them on the board. But you can already see how that might seem to the officer like a disparagement of his abilities. It isn't. It's just that they're working for different purposes. Going back to the evidence used at trial, you've looked at how trials work, and you've looked at the 4th, 5th, and 6th Amendments. Also take a look at the 8th and 14th Amendments if you have some time, because those will play a part in our class as well. But the amendments really will show you that we have a system that is designed to protect the defendant's rights before we take away his or her freedom. The 4th, 5th, and 6th Amendments really do care very essentially with trial practice and the ways that we prove defendants guilty before we put them in prison. What ways do we prove that defendants are guilty? Well, even though the beyond a reasonable doubt standard is very high, very hard to get to, we have a lot of tools at our disposal. The basic kinds of evidence divide into two possible categories: direct evidence and circumstantial evidence. Direct evidence is pretty obvious. In fact, it's almost so obvious it can be hard to think of direct evidence. Direct evidence is evidence so clear that you don't need to make any inferences for it to be used. If there is contraband, that contraband is direct evidence. That contraband is itself illegal, and its mere existence is evidence. Same with a confession by a defendant. A defendant's confession is direct evidence that they did it. They're saying they've committed the crime. Circumstantial evidence requires an inference. It's secondary. That doesn't mean it's not good. You might have heard disparaging references to circumstantial evidence in trial practice or movies. Oh, that's just circumstantial evidence. But that's not the case. Circumstantial evidence is good evidence. It's useful. In fact, many cases are based primarily on circumstantial evidence. Still, it cannot be used solely to get a conviction. It's just very helpful for establishing beyond a reasonable doubt that the defendant committed the crime. The motive, means, and opportunity to commit a crime are often used not just in the investigation phase, but in the prosecution to show that the defendant is the person who most likely committed the crime. Defense will attack circumstantial evidence because it doesn't directly show that the defendant committed the crime. But circumstantial evidence can be so overwhelmingly probative that it's essentially used to convict. For example, shoes fitting the defendants leading to a house, fingerprints of the defendant inside the house, DNA evidence left by the defendant on the victim, and a car matching the defendants leaving the scene, seen by witnesses. All of that is circumstantial evidence, but if you put it all together, that could be used to convict the defendant. You wouldn't need to call the victim to the stand, who would, if she gave an identification, provide direct evidence. If evidence is going to be admitted, it's got to be relevant. Well, what do we mean by relevant? Remember that all evidence has to be used to make the defendant's guilt more or less likely to be true. If evidence makes the determination of the action more probable or less probable, then that evidence is probative. Relevance is a very low standard, but it's essential. If you don't have relevance, it cannot be admitted. Basically, relevant evidence is evidence that would make a juror think either this person surely did or surely did not do it, or I can infer that the defendant did or did not do it from this evidence. So circumstantial evidence is also relevant because it can be used to make inferences upon the defendant's guilt or not guilt. The bottom line is that evidence has to be relevant to be admissible. Things that are not relevant are actually quite hard to think of. What would count? Well, not much. If the defendant has committed crimes in the past, well, that makes them more likely to have committed crimes in the future. That's relevant. If the defendant is a known liar, well, that makes them more likely to be lying on the stand. That's also relevant. If the defendant has a good character, straight A's, never got in trouble, well, that's relevant too. Same with non-character evidence, such as confessions. If the defendant confessed, that's relevant. Even if the defendant had the confession beaten out of him or her, that evidence still is relevant. We'll talk about evidence that's relevant but not admissible, such as beaten confessions, in just a few minutes in the next video. But the bottom line is that relevant evidence is always admissible unless provided by the Constitution. Evidence that was forced out of the defendant would violate the Constitution. Or by other rules of evidence, say evidence against character. Character evidence is also not permitted by federal evidence rules. Let's talk again about our fact pattern. John Doe driving late at night with a female passenger. His car is driving erratically and he's pulled over. That right there is relevant evidence. Driving your car erratically shows that you're under the influence of something. This makes it slightly more likely that John Doe was aware there were drugs in his car. That would be relevant, under the simple standard of whether the evidence is relevant or not. It's circumstantial evidence, but that's okay. The officer approaches the car and sees several small Ziploc bags containing white powder in the back seat. That's direct evidence. That's relevant evidence of contraband or narcotics. Obviously, in order to admit that evidence into trial, you would need to have some sort of test done to show that it was cocaine. You can't just put them on the table in the courtroom and have the jury assume that they can determine what cocaine is. You would need to have at least some testimony or a test to demonstrate that that actually is what it purports to be, which is a contraband or illegal substance. Notice that this is the difference between knowing the person is guilty and proving that they're guilty. The officer sees bags of white powder in the back seat of a car. He knows what they are. He can infer that. But he can't just accept that for a conviction. We have to show that it is cocaine, based upon more than just simple sight, which the jury cannot rely on. When Doe is asked to step out of the car, the passenger, a woman who we don't know who she is, takes off running. We can't find her. That's evidence of John Doe's guilt, but he can also use this as evidence that he is not guilty. This is probative evidence going both ways. The passenger took off. This lack of evidence, this gap, can be used by both parties to demonstrate, well, whatever they want. Because it's not evidence, they can use it as an inference, absence of evidence. The defense could say, The woman who owns the drugs took off. We don't know where she is, and we don't know who she was. This lack of evidence can be used to infer that John Doe is not guilty, that he did not possess the contraband. In fact, Doe even said the drugs were hers. This also cuts both ways. The prosecution could use this to show that Doe knew that there were drugs and that they were in the back seat. But the defense could use it to show that even at these early stages, Doe was abstaining from asserting possession of the drugs. He's read his Miranda rights and refuses to speak. Now, we know that someone exercising their Miranda rights cannot be used against them in court. But without that rule, that would be relevant evidence. Someone refusing to speak to an officer is relevant. It might show that they have consciousness of guilt. We'll talk about why that's not allowed against the defendant when we talk about Miranda rights. The defendant has several prior convictions for sale of narcotics. Also, relevant evidence. A jury might infer that this person has dealt drugs in the past and they're likely to deal drugs in the future. That's not an absurd proposition. However, we also generally disallow this kind of evidence, and we'll talk about why later on today. But think about it. This is all relevant evidence, and some of it might not be admissible. Is that fair? Is that right? That's the system we're setting up. We're setting up a system where even if we know the defendant's guilty, if we cannot prove it, that doesn't matter. You have to prove it in a court of law. You have to prove it to the jury. And getting that evidence into court involves collecting it legally, not violating the Constitution, and ensuring you follow other evidence rules. If you don't follow those rules, that evidence won't be admissible. And if it's not admissible, it might as well not exist because it won't be allowed into court. And if it doesn't get into court, you can't use it to prove the defendant's guilty. At any step of the way, this evidence could have been tainted. If the stop was illegal, if the questioning violated the Fifth Amendment, if any of those happened, the entire substantive evidence would be thrown out of court and we couldn't get a conviction. Even though we know John Doe is guilty, we couldn't prove it. And if we can't prove it, we might as well not have tried in the first place because we've accomplished no conviction. Remember, that's the difference, and that's how our system works. It's not enough to just know he's guilty. We've got to prove it.